and welcome back to the channel. My name is attorney Stanley Helinski. I am an attorney of about 25 years. I practice in trial courts and appeals courts, the First Circuit Court of Appeals, federal courts as well. Today I'm talking about the liability of public employers as it relates to public employees and members of the public. I'll explain in more detail, but that means bringing lawsuits against the government for the conduct of public employees that may cause harm or damage to members of the public. Let me first say this. The United States Constitution prevents any members of the public from bringing a lawsuit against the government for any reason. Hard stop. When the founders drafted the Constitution, they determined that having members of the public sue the government for the actions of government employees, for the functions of government, would sort of grind government to a stop. They'd be entrenched in defending lawsuits for every little thing that they did, and they'd be second guessed for every little thing that they did. So they forbade it. So if that's the law, then why do we see lawsuits against the government all the time? So how that changed over the years is that once the government started doing things that were non-governmental in nature, like entering into contracts or making investments, so many other functions that aren't necessarily government functions, they started to expose themselves to liability. So the government enters into a contract and they breach that contract, it breaches that contract, and someone brings a lawsuit for the breach of that contract. Well, courts started to allow those lawsuits, and appeals courts started to uphold judgments based on breach of contract against the government despite the sovereign immunity clause. They were essentially reasoning that the lawsuits were allowed because the government wasn't really doing something that was a government function. They were kind of acting like a third party. And if the government is going to choose to act like a third party, then they're not going to have the sovereign immunity protections that were given them in the Constitution. So what happens? Government lawyers freaked out. The doors of lawsuits was starting to creep open. And so legislators, being smart and figuring out how to do things, decided to compromise. Both the federal government and the state government decided that they would carve out an exception to sovereign immunity. So even though the US Constitution had this sovereign immunity bar in the Constitution, and for years they had relied, they being the government, had relied on that bar, they started to see the door open a little bit, and they were willing to concede some liability in the context of certain situations. So it was very, very smart to do that because the doors were opening anyway. And by carving out exceptions to sovereign immunity, they were allowed to put some borders and boundaries and limitations on what actually could be done. And over the years, that statute, that cutout, has been upheld over and over again. So when it comes to federal claims that are federal in nature, that fall under the US Code or whatever, the name of the code is the Federal Tort Claims Act. That is the act that is the carve out from sovereign immunity that allows a member of the public to bring a lawsuit against the government. In Massachusetts, it's the Massachusetts Tort Claims Act. You go to different states, it's going to be a very similar thing. But effectively, it creates limitations on how much can be recovered, how much may be recovered. It puts limitations on how long until you can bring a claim. I mean, it really puts some significant limitations while allowing what was happening anyway, which was lawsuits to be sustained against the government. So to that end, today we're talking about a case that was just released by the Massachusetts Appeals Court involving an MBTA driver. Now, MBTA, the Massachusetts Bay Transit Authority, is that agency in Massachusetts that operates all the buses and the public transportation, those big city buses that you see everywhere. Now, this applies in other states as well. Every state has, their big buses and transit systems and such. In Massachusetts, it's the MBTA. So I'll explain the facts in detail a little bit more later, but essentially a bus driver stomped on the head of an individual trying to get on his bus during a blizzard. Those are essentially the facts. Now, as we're going to talk about, the Mass Tort Claims Act, as well as specific state law, prevents a public employer from being liable for the actions, the intentional actions of a public employee. However, the plaintiff in this case, the poor fellow who had his head stomped on, alleged something a little different. The name of the case is Matthew Theisz versus the Massachusetts Bay Transit Authority in Derek Smith. The docket number of that case is 23-P-111. The facts are pretty straightforward. The bus driver, whose name is Derek Smith, was driving bus number 896 in Lynn, Massachusetts during a pretty heavy snowstorm. The plaintiff, who was trying to get back into Boston, was banging on the outside of the door to Derek Smith's bus. He was trying to get Derek Smith to open the door to ask Derek Smith which bus would take him back into Boston. Well, the two get into a heated exchange, and eventually the plaintiff calls Derek Smith an a-hole, turns around and walks away. Well, Derek Smith comes down the stairs, opens the door, catches up to the plaintiff, punches him in the head, causes the plaintiff to fall to the ground, and then starts to stomp on his head. The plaintiff, suffering significant injuries, was transported to a local hospital where he was treated for traumatic brain injury. So a lawsuit, of course, was filed, but in this case, it was discovered that Smith had a little bit of a history with this kind of stuff. So it turns out when Derek Smith was hired part-time in 2010, he had this whole history of infractions based on unsafe driving, complaints that he's been hostile toward members of the public, he was hostile toward his supervisors. Well, he was promoted to full-time in 2013 when in October of that year, Derek Smith attacked a bus passenger and in doing so crashed the bus into 3 parked cars. Now, you'd think he'd get fired for that, but he was given a 1-day suspension, during which time I'm sure he didn't take any anger management courses. He was then returned to full duty when in 2014, his bus was pulled over by a police officer for a traffic infraction, got into an argument with the police officer. He wouldn't give the police officer his registration or license. He got arrested, and then all the passengers on the bus got stranded. Nothing happened after that. When this incident occurred in 2016, Derek Smith was a full-time employee of the MBTA in good standing. So a lawsuit gets filed. Immediately, the government files a motion citing General Laws, Chapter 258, Section 10C. Now, General Laws, Chapter 258, 10C, which goes along with the sovereign immunity arguments, states that a public employer, the government, is exempt from liability for the intentional acts of a public employee. That includes the intentional tort of assault and battery, which took place here. Now, the rationale for Section 10C, so in other words, the reason why such a law even exists is that the government doesn't really have control over the actions of a rogue employee that decides to go stomp on someone's head. I mean, so the question is like, how do you hold an agency responsible when an employee does something so rogue as what Derek Smith did? That's the rationale for giving the government protection against these kind of actions. Now, we're talking about intentional torts. Tort is just a legal word for a lawsuit. So a negligence lawsuit, an intentional lawsuit. The difference there between an intentional tort and one of negligence, torts are usually grounded in negligence. A bus driver who drives his bus negligently into someone else, like when Derek Smith hit those parked cars, for sure the government's going to be on the hook for that. That's a negligent tort. So the statute that we're talking about, 10C, applies to intentional torts. There's a significant difference there. And again, the government just can't predict that there's going to be this conduct of a rogue employee, right? That's the reason for 10C, and that's the argument that was made by the government in this case. The trial court in this case denied the government's motion to dismiss the case based on 258-10C. And the appeals court upheld the trial court's denial of that motion, the decision to deny that motion. So how can that be when the law so clearly states that the government can't be held responsible when a public employee decides to attack a member of the public? Well, this is your lesson of law for the day. Just because something is what it appears to be doesn't make it so. There's almost always a way around it. A good lawyer will always be on the search for that. A really good lawyer will almost always find one. Well, in this case, the trial court reasoned and the appeals court agreed that this wasn't a situation where the government sat back and did nothing wrong. Typically, having a public employee stomp on the head of a customer isn't something that the government could really foresee. But in this case, both the trial court and the appeals court said that there was evidence that maybe the government could have foreseen this happening.
What I'm interested in, at least for the moment, is the judge below said that viewing the evidence in the light most favorable to the plaintiff, one could find that, well, actually, this is actually about Section 2. On the merits, one could find that he was acting within the scope of his employment because maybe he was trying to keep the bus on schedule and didn't like the guy interfering with it or whatever. But that's about the merits. Here we're just talking about, is there immunity? Right? Just because there's no immunity doesn't mean the MBTA loses. It might be that this guy was doing something totally unforeseen and unforeseeable, and as a consequence, the MBTA isn't liable on the merits. We're trying to figure out if you're immune under 10J from even having to answer the claim.
This guy had already attacked a customer in the past, wasn't really penalized for it, much less fired. The appeals court said in this case that the plaintiff should at least be able to make an argument to a jury that the government should have foreseen that something like this could have happened. It's kind of a blood on the tracks kind of argument. You know, if somebody does something once, they're likely to do it again. Einstein's theory of insanity, doing something over and over again and believing in a different result. So there's an actual lawsuit that you can bring against a person or an entity that's called negligent hiring or negligent retention. And it stands for the proposition that an employer knew or reasonably should have known that its employee would do something like this. That's why employers, especially public employers, do background check. If you've had a background check done before, this is the specific reason why background checks are done. If the company or the government ever gets sued, they can say, here's the investigation that we did into this person's background. There was no indication that they would have ever done anything like this. We're not responsible, the employee is. That's the reason for background checks. So in this case, the appeals court held that General Laws Chapter 258, Section 10C did not provide protection to the government, where the plaintiff alleged, as they did here, that the government negligently hired and retained Derek Smith as an employee, and that it knew or reasonably should have known that something like this was going to happen. That's called causation. So the moral of the story is the sovereign immunity clause started to erode away over the years, and so different statutes were enacted to allow lawsuits, but only for specific causes of action. Well, we have arguments all the time now, as we see in the Theisz case here that we're talking about today, that it's not always clear what falls within those carve-outs for sovereign immunity. And as the appeals court has said today, if a public employer doesn't do a sufficient background check, A, or 2, does a background check and discovers concerning information and don't act on it, or C, something happens and the employer, the public employer, doesn't take remedial measures or fire the person and lets them just keep going on business as usual, then it's entirely possible if somebody gets injured that a lawsuit is going to happen against the government and the courts aren't going to give the government any protections. So that's your legal snippet of the week. Please let me know in the comments if there's a topic that you would like me to discuss or to analyze. As always, this is not legal advice about your case. It is general information that may or may not apply to you. You should always speak with a lawyer when applying law to the facts of your case. Thank you for watching. Please subscribe to the channel if you'd like to see up-to-date legal analysis on topics that may affect your life. This is the new channel, so if you enjoy this content, please share it with others, and we'll see you next time. Thank you.